Could you please state your name and spell your last for the record?
Kevin, R as in Robert Davis, that's Davis.
Could you tell the ladies and gentlemen of the jury a little bit about yourself, sir?
Well, I'm a retired law enforcement officer. From 1982 until 1990, I was a deputy sheriff for the Summit County Sheriff's Department. In 1990, I was hired by the Akron Police Department. I worked there until April of 2021, so for 31 years I worked for Akron PD.
What do you do now, sir?
I'm a consultant and expert witness and trainer that trains law enforcement officers on use of force.
So you mentioned that you started in the 1980s. How long have you worked in law enforcement?
Well, not counting what I do now, it was 39 years.
I want to talk to you about the different positions you've had within the field of law enforcement. Can you walk the ladies and gentlemen of the jury through those positions?
Certainly. I started out working for the Sheriff's Department. I worked in corrections at the Summit County Jail, where I did direct supervision of inmates in the jail. I then transferred to Road Patrol, where I worked uniform patrol in about 4 different townships in Summit County, southern and northern Summit County. I then was hired by the Akron Police Department. I had to go through a second academy at Ohio Peace Officers Training Academy in London, Ohio. And then I was assigned to, once I was sworn in, was assigned to evening patrol from 7:30 at night till 3:30 in the morning in the downtown area of Akron. And then when I got my regular partner on the east side of Akron, I then, a new unit formed somewhere around 93, which was originally it was called the Uniform Narcotics Unit, designed to specifically target high crime area and back then open-air drug markets in the city of Akron. Later on, we changed our name to Street Narcotics Uniform Detail, or SNUD Unit, and I did that for 6.5 years. Collateral with that, after about a year or so, I was selected to become a member of the Akron Police Department SWAT team, which I did for about 12.5 years. I would later on become the lead instructor for the SWAT team and a team leader. As I said, I did that for about 12.5 years. I transferred from the SNUD unit after 6.5 years to the Akron Police Department Training Bureau, where I worked for about 19 years. I was the primary use of force instructor. That was the hands-on or subject control. I became the senior firearms instructor. I taught building searches, traffic stops, the legal aspects of use of force, a variety of different topics.
Did you ever teach police cadets at the Ohio Peace Officers Training Academy?
Yes, I taught in Ohio. You have certified academies. Akron had their own. University of Akron had one, and I taught at both of those. I taught just briefly for the Kent State University Academy, and then I was hired as an adjunct instructor after a number of years. I think it was like 2009, where I worked for OPATA, it's called, in the Ridgefield campus, up in the northern campus of Summit County. And I did that for 4 or more years, where I taught a variety of different subjects, from use of force investigations to practical aspects of arrest and control, firearms, everything from pistol, revolver, shotgun, submachine gun, carbine. I taught all of that, SWAT tactics, a variety of different subjects.
Did you use the acronym OPATIC?
OPATA, yeah, correct.
OPATA, I apologize. And what does that stand for?
Ohio Peace Officers Training Academy.
You mentioned some of the fields that you train police cadets in. I want to go over those. Do you train them in use of force?
I did. I'm kind of retired. I did it for a long time, and you get old, and I no longer teach in basic academies, but I taught them in arrest and control tactics, yes.
What about, you mentioned firearms earlier?
I did. I was actually through OPATA, I became a train the trainer, so I was able to certify instructors for the state of Ohio.
Defensive tactics?
Yes.
Active shooter and rapid deployment?
Yes.
What about, you mentioned that you were a SWAT team lead. Did you ever train with respect to other SWAT teams?
Yes, I taught not only at OPATA for tactical operators or tactical team members, but also for the Ohio Tactical Officers Association.
Have you been published in your field, Mr. Davis?
I have. One time I wrote for all the periodicals, Law and Order, Tactical Response, a variety of different online portals, Law Officer, Officer.com. I also wrote a book on use of force investigations.
Do other experts in your field rely on those authored works by you?
Yes, proudly, my book is required reading from the Federal Law Enforcement Training Center in Glencoe, Georgia, and their use of force instructor program.
Have you presented at conferences on use of force with regards to whether or not a use of force decision was reasonable?
Yes.
Do you belong to any professional organizations within the field of law enforcement?
Yes, I'm a member of the International Law Enforcement Educators and Trainers Association, or ILETA, and also AFI, or the Association of Force Investigators.
Have you won any awards recognizing you for any type of achievements within law enforcement?
Yes.
What are those, sir?
In 2018, I was given the Distinguished Training Award by the Attorney General's Office in Ohio. And in 2019, I was inducted into the National Law Enforcement Hall of Fame as Trainer of the Year.
Congratulations.
Thank you.
Have you testified as a use of force expert here in the state of Ohio?
Yes, throughout the state of Ohio.
In municipal court?
Yes.
What about common pleas courts?
Yes, can't even recall how many different counties now that I've testified in.
How about federal courts, sir?
Yes,
Have you been declared an expert in each realm of those courts?
that is correct.
Have you testified in other states as well,
Yes,
both federally and at the state level?
yes,
So you travel across the country testifying.
probably too much if you ask my wife.
Have you given opinions in those cases as a use of force expert based on your training and experience as an expert to a reasonable degree of professional certainty?
I have, yes.
And is any opinion you offer today going to be to a reasonable degree of professional certainty?
It will, yes.
At this time, Your Honor, I would like to tender Mr. Davis as an expert in law enforcement training.
He can render his opinions.
Thank you, Your Honor. Now, Mr. Davis, I want to talk about how you determine whether or not to consult on a case. What process do you use to determine whether or not to take on a case?
Well, I don't solicit cases. In other words, I don't call attorneys. I usually get a call or an email from a law group asking if I'm interested in working on a case. Before that, before I am retained, I ask to review as much material as I can about the case. So many attorneys send just videotapes, and that's not enough to render an opinion. So I want the maximum amount of information that they have at that time in order to say whether I can work on the case or not.
Sure, so fair to say you like to review the material before you make the decision to take on a case as a consultant.
Yes.
Have you reviewed use of force cases and decided not to take them?
Yes, over the last couple of years, I have looked at cases and told the attorneys, I can't defend your client.
Have you examined use of force cases and found that the use of force then was unreasonable?
Yes, or at least not anything that I could work on, yes.
For myself and Mr. Collins too, right? We've certainly consulted you on cases where you've said, hey, I can't take that case. Is that correct?
That is correct.
So just because you agreed to work on a case does not mean you formulated an opinion at that time that you're getting these materials that you like to review. Is that fair?
Well, the way discovery works is you get a little bit of information at the beginning, and then it trickles in. As more and more information comes in, it may change things. But by and large, if I have the investigative report and as much information as I can, the onset, it allows me to formulate an opinion. Unless something else comes up that changes that opinion, then I'll work on the case.
Do you charge a fee for your work, sir?
I do, yes.
What is that retainer fee?
It is $3,500.
Is that industry standard for consultants in your field?
I charged too little. But it's industry standard or thereabouts.
Does that retainer fee come with an opinion attached?
Absolutely not. Well, let me rephrase, opinion one way or another, but no guarantee.
Sure. Do you charge a fee to testify?
I do, yes.
And is that fee industry standard?
Less than most.
Have you worked on cases, sir, on behalf of law enforcement officers in the past?
I have, yes.
Have you worked on cases against law enforcement officers in the past?
Yes, I have not only testified at termination hearings as a result in officers losing their jobs, but I've also recently been retained in a case of excessive force on an officer.
So after you get the material and decide to take a case, what's your next step in the process of how you review a case?
Well, as I said, it's not a boom, you get everything in one big package. It's a trickle, and that's as the state develops the material too. But in this case, and in many cases in Ohio, they're investigated by Ohio BCI or Bureau of Criminal Investigation. And usually when I get that investigative packet, it's pretty detailed and has a lot of information, including everything from witness statements at that point to scene analysis and diagrams and photos and videos, et cetera. So the more I get, and it's a continuing process because even before trial, you're getting new things to review.
Now, were you eventually provided all of the material that you felt you needed in order to come to an opinion in this case?
I don't know if I got all of the material, but I got enough to make an educated opinion, yes.
And did you make us aware of what your initial opinion was?
I did, yes.
Did we ask you to prepare a report?
You did, yes.
And did you prepare a report?
I have, yes.
Is this the same process, sir, you go through for each and every type of case that you evaluate?
It is, yes.
And is this process accepted in your field?
It is, yes.
Now, I want to get to your opinion, sir. What opinion did you come to after analyzing all the materials with respect to Connor Grubb's use of force on August 24th, 2023?
That although it was a tragic incident, that the Officer Grubb's actions were within generally accepted practices, within the Blendon Township policy and procedure, and within the laws of the state of Ohio, as well as the legal standards on police use of force.
You used a phrase, generally accepted practices. I want to talk about generally accepted police practices and how they relate to this case. Where do we get generally accepted police practices from?
Well, this is kind of a contested.
Turn off your phones.
So sorry, sir, you said, well, this is kind of a contested.
Yeah, the generally accepted police practices and standards are kind of contested because, in my opinion, in Ohio, for a law enforcement officer in Ohio, you would have, first of all, the constitutional standards. Those are the Supreme Court decisions that inform police officers on use of force, both deadly and non-deadly. Then we look at state law. There are other Supreme Court precedents, but then we look at state law, and then agency policy. These would be the things that would inform or create generally accepted police practices and standards. Some things aren't covered by that. There's no book on certain things like tactics. There's no book on where to stand, how to approach, et cetera. There are recommendations, but what happens is that opinion enters into there, and these should be looked at in an objective way, not subjective. In other words, I may have a different opinion than somebody else about tactics, but in reality, is it within the law and generally accepted standards?
So it sounds like the generally accepted standards you said come from constitutional standards and state law. Would you agree with that?
Yes, those are the legal standards, absolutely.
And do you train police cadets as to what those standards are?
I have, yes, as well as in-service officers.
And that's, again, here in the state of Ohio?
That is, yes, and throughout the country, I've trained law enforcement officers.
Now, earlier you discussed the various aspects that you have trained police cadets on with respect to tactics and use of force. Do you know how many hours of training cadets need to complete at the Ohio Peace Officer Training Academy in order to be certified to enforce the laws here in the state of Ohio?
There is a minimum number of hours. I think it's around 740 hours minimum that the state requires in their curriculum. But agencies are allowed to exceed that. For instance, Akron Police Department Academy exceeds that. I'm sure that Columbus does as well by adding agency-specific training in there, as well as say there's 80 hours of firearms training required. The agency may feel that that's the minimum number, but not sufficient for their officers, so they exceed that. And it's usually in those areas like hands-on control tactics, firearms, the law, et cetera, that agencies or academies exceed that.
And do agencies continue to train their officers yearly?
They should. They should. Ohio has this new program called Continuing Professional Training, or CPT, where they require hours that agencies do. Not just in the past, unfortunately, agencies would just do firearms qualification each year, and that's about the only training they would give their officers. CPT requires that they either attend hands-on or through the computer by streaming various programs each year.
Why is there so much training, sir?
I would argue that there's not enough training, that, but it's unfortunately, it's a budgetary thing, because the longer a cadet is in the basic academy, the longer he is not on the street. And agencies, especially today, are really pushed to get officers out on the street.
Earlier you mentioned you train cadets with respect to constitutional standards. What are we talking about here? What constitutional standards do you train cadets on?
Well, there's a variety of different things. My specialty is use of force, which is a Fourth Amendment question. During my career, that has changed. Early in my career, it was the 14th Amendment, or due process, and the standard was shock to conscience. In 1985, the Supreme Court looked at use of force, specifically deadly force, in Tennessee versus Garner. And they said that the shooting was a seizure. In other words, the officer shot a subject in the head, and that seized the person. And because of that, the Fourth Amendment applied. The Fourth Amendment is the objective reasonableness standard. That was echoed in 1989 in the Graham case, Graham v. Connor. And that applied the Fourth Amendment seizure test, or objective reasonableness, to non-deadly use of force. And since then, we've had other cases.
What about here in the state of Ohio, sir? What specifically here in Ohio dictates how you train police cadets?
Well, OPATA has a curriculum. You have cadets and in service as well, and the CPT training required that in-service officers get legal training as well. But once again, that curriculum is written by the Ohio Peace Officers Training Commission, and it includes those standards I've talked about, the Fourth Amendment, Graham v. Connor, Tennessee versus Garner, and a variety of other cases.
Any cases here in this state in particular with respect to use of force?
Yes, the White case, State of Ohio v. White, that applied. One of the issues in the past with the Graham v. Connor case was it was a civil case. And the State of Ohio v. White, the Supreme Court in Ohio applied Graham v. Connor to criminal cases in the state of Ohio. So State v. White, and it really fleshed out Graham v. Connor and the standards quite a bit.
I want to talk about a couple cases, cases that you just mentioned, sir. You mentioned Tennessee versus Garner. What specific generally accepted police practices do you get, or do you train police cadets on from Tennessee versus Garner?
Well, once again, the application of the Fourth Amendment to the use of deadly force, saying that shooting was, if it struck the person, it was a seizure, or if the person complied with, in other words, through means forcibly applied, or the person complies, you have a seizure. But in the Tennessee versus Garner case, it was that in order to use deadly force, officers had to have probable cause that a crime involving the infliction or threatened infliction of serious bodily harm had been committed, and that force was necessary to seize that person, to bring them into custody, and where applicable or where possible, some type of warning is given. That's the Tennessee versus Garner case.
And is that a generally accepted police practice?
It is throughout the country.
You mentioned Graham versus Connor. What type of generally accepted police practices come from Graham versus Connor?
Well, Graham v. Connor once again applied the Fourth Amendment. The subject, DeThorne Graham, was not under arrest. The officer had reasonable suspicion to believe that a theft offense had been committed based on DeThorne Graham's action. He was actually a diabetic, was going into insulin reaction, and had kind of rushed out of a convenience store, which attracted Officer Connor's attention. Officer Connor tried to stop him. Graham did some interesting things because he was going into this diabetic reaction, and force was used upon him. And that was the first time that the Supreme Court had applied the Fourth Amendment or objective reasonableness standard to use of non-deadly force.
What does that standard say? How does that standard equate to you analyzing this case?
Well, in Graham v. Connor, there's a variety of different things. It looks at the totality of the circumstances. It looks at what's called the Graham factors. It looks at the officer's perceptions, and it weighs. You balance the person's right to be free from unreasonable searches and seizure with the state's countervailing need to apprehend the person. So that's a balancing test. And there's a variety of different things, such as not to be viewed in hindsight, et cetera.
Now, you mentioned the Graham factors. How do the Graham factors come into your analysis? And what are the Graham factors?
Well, the so-called Graham factors are referred to by the Supreme Court, but it's not an exhaustive list. The Supreme Court in Graham said that reasonableness, which is what we're talking about, is incapable of precise definition or mechanical application. So there's no precise answer to reasonableness. However, factors, and it's a non-exhaustive list, are severity of the crime in question, whether the subject posed an immediate threat to the officer or others, and whether the person was actively resisting arrest or attempting to evade arrest by flight. These are called the Graham factors, but there are other things that can factor in. That's totality of the circumstances.
And do you teach police cadets about these Graham factors?
I do, yes. Not just cadets, but in-service officers throughout the country.
Did you analyze the Graham factors here in this case?
I did, yes.
I want to talk about those one by one. You mentioned the first one was severity of the crime in question. Tell the ladies and gentlemen of the jury what that means.
Well, oftentimes police officers in an initial encounter with the subject, say it's a jaywalking. A person, a city is asking beat officers or foot patrol officers to enforce jaywalking because they have a problem with it in the downtown area. And so the officer attempts to stop this person, to cite them or to question them about the jaywalking, and the person produces a gun and tries to shoot the officer. It's not the severity of the original crime, jaywalking, but it's what actually happened, transpired, which is attempted murder of the police officer. So when we talk about severity, oftentimes innocuous situations like suspicious persons, and even more things like domestic violence, an officer may go in there to make an arrest for a misdemeanor, but then end up in a fight for their life.
Did you analyze the severity of the crime at issue here?
I did, yes.
And can you tell the ladies and gentlemen of the jury what you found with respect to your analysis to that first Graham factor of severity of the crime at issue?
Well, Ms. Young committed a felonious assault, in my opinion, when she intentionally drove her car into Officer Grubb. That's caused or attempted to cause serious physical harm. Because she did that in the commission of a theft offense, that would be aggravated robbery, using serious physical harm in the commission of a theft offense.
Are those crimes severe here in this state?
Yes, they're both felonies.
I want to move on to factor number 2. What was the second Graham factor that you analyzed?
Whether the person poses an immediate threat to the officer or others.
Sir, what do you mean by threat?
Well, threat is pretty obvious that the person, through their actions, will cause, and this is viewed in the officer's shoes at that time. In other words, what that officer knew. Did they have reasonable perceptions to believe that the person was posing a threat of death or serious bodily harm? When we talk about a gun, that's obvious. When we talk about a baseball bat, that may be something different, but an obvious threat to the officer.
So you mentioned that whether the suspect posed an immediate threat. We just talked about threat. What do you mean by the word immediate?
Well, immediate and imminent are used pretty much the same in Ohio, meaning that it's ongoing. Imminent is actually that it's pending or it's happening. Immediate is right here, right now. So in those cases, an immediate or imminent threat. In the state of Ohio, an imminent threat or pending assault would be a deadly threat.
Now, what did you find here with respect to that second Graham factor of whether the suspect posed an immediate threat to the officer or others?
Yes, once Ms. Young unfortunately accelerated into Officer Grubb, that was an immediate threat based on the vehicle, the acceleration into an officer standing there.
Now, what do generally accepted police practices say for an officer to do when they're confronted with an immediate threat to themselves or to others?
Well, depending on, there's a variety, that's a wide-ranging question, but obviously if they believe that the suspect, reasonably believe that the suspect poses a threat of death or serious bodily harm, then they can respond with deadly force.
So, did the suspect pose an immediate threat to the officer or others here?
I believe Ms. Young did, yes.
And specifically, sir, what was that threat?
It was the 2008 Lexus ES sedan.
Is there a difference between a perceived threat and an actual threat?
Well, an officer is allowed, for instance, if the officer perceives that the suspect is reaching into his waistband to access something, in his reasonable perceptions, a handgun, for instance, and coming out, then that is a perceived threat. And that can be enough based on the totality of the circumstance for an officer to use deadly force. That's State of Ohio v. White. The subject did not have a gun, was reaching, and the officer shot the subject. An actual is when the gun comes out or is firing towards an officer.
So, was there a perceived or an actual threat here?
Now, this was an actual ongoing threat
Why do you say it was actual and ongoing, sir?
because Ms. Young was accelerating into the officer who was a pedestrian standing in the parking lot.
I want to talk about cars in general as threats. Can a car be a deadly weapon?
Under some circumstances, based on the subject's actions, yes.
How much did the car, the 2008 Lexus ES sedan, weigh, if you know?
It's in my report. I think it was over in excess of 3,500 pounds.
Do cars injure or kill police officers every year?
Oh, yes. Not only accidentally, unfortunately, we've lost several Ohio officers that have been hit directing traffic or helping disabled motorists, et cetera. That's accidental. Intentionally, in my report, I document that for the 10 years from 2014 to 2023, 47 officers were killed by vehicles, throughout the United States, intentionally killed by subjects. This is less than handguns, but more than rifles used against officers, more than shotguns used against officers, more than knives. So vehicles and vehicle-borne threats, as we can just see from the news recently, are a real threat to law enforcement officers.
Are in-service officers as well as police cadets trained on how vehicles can be deadly weapons?
Well, some of that is common sense, and it would depend on the agency, but yes, that's normally covered. It's a real danger, and traffic stops are the source of a lot of training in the state of Ohio because of the risks involved.
But with officers knowing that these vehicles can cause serious bodily harm or death, shouldn't officers just be trained to let the person go?
Yeah, that's not normally an option in law enforcement. We have issues such as nonfeasance or malfeasance where failure to enforce a law could lead to the officer being charged or disciplined. So normally, we just don't let criminal suspects drive away.
In your training and experience as a law enforcement officer, sir, have you responded to people being hit by cars?
Unfortunately, yes.
Have you seen serious injuries been caused by people being hit by cars?
Yes, I've seen a person actually being, the end result after a person was driven over where they actually rolled underneath the transmission of the vehicle.
Based on your experience, can even a slow-moving car cause serious injuries?
Oh, yes.
So we've been through the first two Graham factors, the severity of the crime at issue and whether the suspect posed an immediate threat. I want to talk about the third Graham factor. Tell the ladies and gentlemen of the jury what that third Graham factor is.
Whether the person is actively resisting arrest or attempting to evade arrest by flight.
What does actively resisting arrest mean?
Well, it could be a variety of different things, but it could be passively resisting, as in a sit-in demonstrator who refuses to get up, or it could be somebody that's actively assaulting or attacking an officer. So that would be equate to actively resisting. Yeah.
What about refusing to comply with an order? Would you classify that as resisting arrest?
It is. I mean, everything from trying to intimidate an officer into verbal threats or verbal communication of I'm not doing it or other more combative terms.
Based on the materials that you reviewed, sir, did Sergeant Moynihan and Connor Grubb give orders on that day?
Yes, I think I counted on Moynihan's video 11 different commands for Miss Young to get out of the vehicle.
Were those orders lawful?
Oh, yes.
Why so?
In the state of Ohio and nationally, once again, generally accepted police practices, when an officer has reasonable suspicion to believe that a crime has been, is being, or about to be committed, the officer can detain the person. They don't have probable cause at that point to make an arrest, but they can lawfully order the person to stop. And if that person is in a vehicle, they can lawfully order the person to exit the vehicle.
So did the suspect resist arrest here based on the information that you analyzed?
Yes. Well, not only verbally and physically by not complying with the sergeant's lawful orders, but also resisted by assault by driving into Officer Grubb.
You mentioned the third Graham factor has an actively resisting part or attempting to evade arrest by flight. Can you tell the ladies and gentlemen of the jury what you mean by attempting to evade arrest by flight?
Well, this can be, say the suspect is on foot. This can be everything from the guy or gal trying to run away, or it can be, pushing the officer trying to get away, or in a vehicle attempting to drive away.
Did the suspect do that here?
Yes.
So is it, in recap, Mr. Davis, are all three Graham factors here?
Well, all three are in every case, but engaged at this, we have felony crimes, including crime of violence and severity. We have an immediate threat by driving into the police officer, and we have a subject that was actively resisting arrest or detention.
You mentioned earlier that it has to be evaluated in the officer's shoes at that time. How do the three Graham factors come into your analysis and your opinion with respect to how it's viewed at the reasonable officer in Connor's shoes on August 24th, 2023?
Now, the question is would a reasonably prudent and well-trained officer in the exact same circumstance have used the amount of force that Officer Grubb did at that time? That's the question put in his shoes, not based on hindsight. In other words, we don't look back later on and say, oh, he could have done this, he should have done that, etc. We're saying at that moment, based on the totality of circumstances, officer's reasonable perceptions, was that use of force reasonable?
And what's your answer to that, sir?
That it was, and unfortunately, the use of deadly force was reasonable.
Now, you mentioned earlier about the Ohio Supreme Court case State versus White. What are the generally accepted police practices contained in State versus White?
Well, it's quite an extensive opinion by the court, but one of the important things is that it talks about even the most erudite police practices expert cannot couch their opinion in rearward-looking or hindsight-based analysis of what the officer could have, should have, or would have done. That's not the question. The question is what the officer did, was that within a range of objectively reasonable use of force.
So you just said could have, should have, or would have done. Did you, that seems to me like you're talking about tactics. Did you analyze tactics in this situation?
Well, you look at tactics because that's part of totality of the circumstances, but I found no legal breach in the tactics. And as I said earlier, tactics are subjective. In other words, standing here, standing there, there's no yellow footprints to tell officers where to stand. There's no, even in basic training, there's no thing, you shall do this, you shall do that in terms of tactics. They're subjective. And as long as they're within the law, then the tactics, what we often find is that people do what's called tactical debriefs. In other words, they go back and look at tactics. Say this is officer-created jeopardy. The officer, if he wouldn't have stood here, then the use of force may not have been become necessary. And that's not the question in an analysis on a use of force. We're talking about the seizure, not general police practices.
Now, you just mentioned the positioning. You're aware, sir, that Connor Grubb was positioned in front of Miss Young's vehicle that day, right?
I am, yes.
What did you find with respect to his position, if anything?
Well, once again, it's much of what officers do is based on context or environment or situation. In this case, and oftentimes, if you've ever tried to back out of a parking spot and can't see the oncoming traffic because of the dark tint of the windows, you know that an officer cannot see into the vehicles very well, and this is a problem for law enforcement. So what we want with positioning, there's a concept called contact cover. Sergeant Moynihan was doing the contact. He was at the driver's window engaging with Ms. Young on and asking her to exit the vehicle. And what we wanted from Officer Grubb, what we would ask is cover, that he provide the sergeant cover. And when you position for cover, you want what's called a triangulation of fire without a crossfire situation. For instance, based on the circumstances, going around to the passenger side and trying to look and see the driver would have subjected Sergeant Moynihan to crossfire situation. Standing in back of the vehicle, I doubt if anything could be seen based on the tint of the car windows. So moving around in front or towards the front of the vehicle is a tactically sound thing to do based on the context, based on the totality of the circumstances.
Is it lawful to be in front of that car?
Oh, yes. Police officers do it every day. I mean, in downtown Columbus, I'm sure you have traffic control officers. It's dangerous to get in front of cars, but it's something that police officers do routinely.
You just said it was permissible, but is it an effective place to cover being in front of the car?
It can be. For instance, contextually, a subject is in a car in a parking deck backed up towards a concrete wall. There's no way for an officer to maneuver around the rear of the vehicle, so an officer approaches from the front. These are contextual questions.
Why shouldn't he have positioned himself right next to Sergeant Moynihan?
It could have, but it would have made a crowded situation. It could have done a lot of different things. But the question is positioning in front of the vehicle, was it lawful? Yes. Was it tactically sound? Yes, based on the circumstances.
Was it reasonable?
I believe so, yes.
Did you analyze anything with respect to timing in this situation?
Yes, I looked at the time based on the body-worn camera videos and the amount of time based on the beginning roll of Ms. Young's vehicle, and then the acceleration into Officer Grubb, and the overall time.
What did you find with respect to overall time? How fast did that happen?
Well, I could refer to my report to just give specifics, if that's okay. The entire time from first contact of Sergeant Moynihan until we see the bullet defect or the bullet hole in the windshield was about 22 and a half seconds. That's the overall time from Sergeant Moynihan's original contact to the bullet defect appearing on the window.
What was the time from when Young accelerated into Grubb to the shot that he fired in this situation?
From that time, original acceleration was about a second and a half.
You said 1.5 seconds?
1.6, I believe I have.
Thank you. And what does Graham say, Mr. Davis, or what do generally accepted police practices say about that 1.6 seconds?
Well, Graham specifically refers that officers are oftentimes forced to make decisions in circumstances which are tense, uncertain, and rapidly evolving. And certainly once Ms. Young accelerated into Officer Grubb, that was a tense, uncertain, and rapidly evolving situation.
Earlier you mentioned a term called officer-created jeopardy. What does the generally accepted police practices say about officer-created jeopardy?
It doesn't. You won't find officer-created jeopardy in the basic academy curriculum in the state of Ohio. You won't find it throughout the United States in curriculum that I know of and in training. Officers are aware of it, but it's primarily an academic proposed thing that officers, by way of their actions, create the jeopardy which led to the shooting. But that's not the law, and that's not generally accepted police practices and standards.
Any constitutional standard or law by which that mentions officer-created jeopardy?
And we recently had this year the Barnes v. Felix case, which came out. Law enforcement training was looking at this as to whether the Supreme Court was going to rule on officer-created jeopardy, but the petitioners, Barnes specifically, said they didn't want the court to look at that. So we don't have a clear, bright line on officer-created jeopardy from the Supreme Court.
So is the clear, bright line then all the constitutional standards that you had just walked the ladies and gentlemen of the jury through?
Yes, including Scott v. Harris and other cases, yes.
So is officer-created jeopardy or that concept mentioned anywhere in Graham?
No.
What about State versus White?
No.
What about Tennessee versus Garner?
No.
You mentioned that officer-created jeopardy is nowhere in the curriculum, you said, for here in the state of Ohio?
That is correct.
So the curriculum here for the state of Ohio doesn't train officers on officer-created jeopardy?
I don't know if individual instructors may teach it on their own, but it's not part of the curriculum, no.
So is it a generally accepted police practice?
No, in terms of the, within the United States, no.
I want to talk about body-worn camera in general. Are you aware if body-worn cameras have any type of limitations?
Yes, for the last 3 years of my employment with the Akron Police Department, I was a detective assigned to the body-worn camera unit. I reviewed thousands of hours of body-worn camera video, worked on multiple police shootings and murders and felonious assaults. And digital video evidence in general has limitations, but body-worn cameras do specifically.
What are those limitations, sir?
Well, the problem is that the camera is not real life. The camera is a two-dimensional image, meaning depth is oftentimes off, but it's a two-dimensional image based on what the camera captures. Usually the cameras are about 12 to 18 inches below the officer's line of sight. So if the officer turns their head to attend to something on their right, for instance, the camera doesn't see that. The camera may capture something that the officer didn't see based on attentiveness. Also, the cameras recorded, the average in the two Axon body-worn cameras in this case recorded about 30 frames per second, which means that there's one picture taken 30 times a second. It's not continuous. The only thing continuous on a body-worn camera is the audio signal. That's a continuous stream. So depending on the speed or movement, things can be missed. For instance, when you compare BWC video from the officers to the Kroger surveillance video, which was captured at 15 frames per second, there's going to be a difference there. There's going to be one less frame, or half the frames per second that are captured. So there's a variety of different things. Visual acuity at night, the camera captures more than what the human eye does. Because of the fisheye lens, things at the outside of the video are oftentimes you'll see a curve to them because of the fisheye. And also, it portrays things as being further than what the human eye would actually capture. So there's a variety of different things. And also one of the things when you're dealing with hands-on people, it doesn't capture what you feel. When an officer has hands on subject and they physically resist, they can feel that, the camera doesn't capture it.
So just because it's captured on body-worn camera doesn't necessarily mean that the officer saw that. Is that correct?
Oh, that's absolutely true.
Now, you mentioned you reviewed body-worn camera in this case.
I did, yes.
I just want to highlight a few of the points about the body-worn camera. The ladies and gentlemen of the jury have seen multiple instances of the body-worn cameras. Any doubt in your mind, sir, that based on your review of the body-worn camera that Connor got hit by that 2008 Lexus?
No, as a matter of fact, I was able to capture both of Officer Grubb's feet off the deck as Ms. Young accelerated into the officer.
Any doubt in your mind that based on your review of the body-worn camera that Connor's hand was near the center of the hood when he fired that shot?
Near or to the right of, well, it would be, if we're in the vehicle, it would be slightly left of center, yes.
If I'm looking at the vehicle, though, it's
It would be
near the center to the right.
Or to the right, correct.
Did you prepare a slideshow to demonstrate why you have no doubt that these things are occurring within the body-worn camera?
Yes,
And is that based on your body-worn camera review of both Officer Moynihan and Officer Grubb?
yes, as well as video workup done by the prosecution's experts.
Permission, Your Honor, to publish the slideshow that Mr. Davis prepared?
You may. Oh, note your objection.
Thank you, Ms. Cook. Sir, I think you have a pointer up there. Hopefully you can click. That one's the laser. If you click the arrow, though, you can walk us through this slideshow and what you analyzed.
We'll try. We know technology.
If you need me to click, then I will be happy to click and assist
All right.
for you.
Okay, what I've done with these images is working with advanced software called Axon Investigate. I was able to create what's called a subclip. In other words, this is Sergeant Moynihan's body-worn camera. This is a small section of that digital video evidence, and I have cropped in to an area at the left front or driver's side front of the vehicle. So we'll be able to see Officer Grubb's foot placement as the vehicle accelerates.
Okay. Again, you can't see his foot placement here, though, right?
No. And once again, as the here we can see, beginning to see, boy, it's awful light right there. We can see the officer's right foot, and you'll notice that the toe of his boot is bent, meaning that it's in impact with the asphalt of the parking area.
Okay.
Once again, as Sergeant Moynihan moves, we're going to be able to see a little bit more. Unfortunately, his arm will preclude seeing some of Officer Grubb's torso or upper torso.
But you can
Once-
see the foot here.
Once again, the toe is flexed as the boot is in contact with the ground
Okay.
or the pavement. Once again, we can see placement. The officer is, if we're in the vehicle, it's to the right of, or to the left of center of, on the driver's side.
And his hand is near the center, at least, of the hood of that car.
Yes, we can't see the hand from this angle, but yes.
What do you see here, sir?
Once again, Ms. Young is kind of torqued to her right behind the wheel, and we can see the wheel is turned to the right, but the officer is still within the path of the vehicle as Ms. Young is accelerating towards Officer Grubb.
Is there contact between the car and Officer Grubb in that picture, sir?
I believe we can see this area here where the hood is making contact. It would be below the vest, around the belt level or lower. So some from waist to thigh contact.
What about his knees and his shin? Would those be a point of contact here as well?
With the design of the vehicle, the bumper would protrude out from the front of the vehicle more than the grille would. So yes.
Thank you.
And here we can see a slide. If you'll notice that Officer Grubb's right foot is beginning to slide along the pavement as Ms. Young is accelerating into him. This is not a step back by the officer. This is a slide motion.
What do you see here?
Here we begin to see the officer's right foot is now off the deck. In other words, the toe, you don't see the boot in contact with the ground. There's no flex of the foot at this point. So his right foot is now off the ground, or off the asphalt. Once again, as Sergeant Moynihan moves, the camera moves a little bit, so we see less of the foot, but it hasn't changed. Same thing here, we're seeing a break, but this is when Sergeant Moynihan is attempting to break the driver's side window with the base of his folding knife. And you'll also notice that Officer Grubb is in the path in the front of the vehicle.
What about there, sir?
Once again, we can see that, as you see up here on the left of the screen, that the officer is once again in front of the vehicle, within the path of the vehicle, despite the fact that the wheels are turned to the right.
And is this just on loop?
Loop? No,
Yeah.
this is one image. For that subclip, I took individual frames at 30 frames per second, extracted them, and incorporated them into the PowerPoint.
Okay.
So each one is a new image. Once again, Sergeant Moynihan retracting and striking the driver's side window.
And
Now
you don't
here,
see- Oh, sorry, go ahead.
originally we saw a slide and a foot come off the deck. Here we can see that the officer's toe is back in contact with the deck. He has moved slightly to his right or to the screen's left, but we're going to see that as she accelerates, Ms. Young accelerates, that both feet will end up off the deck.
Can you show us where both feet end up off the ground,
Certainly.
Mr. Davis?
This is the right foot off the deck. And the left foot off the deck. You can see the heel. And with the angle of the hips of Officer Grubb's hips here, that unless he's got a very long left leg, his foot has to be off the deck. So we can see the heel off the pavement as well as the right foot completely off.
Thank you, Mr. Davis. Did you analyze any type of human factors in this use of force?
Yes, in every situation, in every use of force, there is what we call human factors, which was the human, in this case, Officer Grubb, in the environment. And human factors can pertain to witnesses as well as the subjects involved, but the factors as they engage in their environment, in the totality of the circumstances.
What type of human factors do you mean?
Well, one of the things we look at oftentimes in the use of force is action response. In other words, a subject acts, an officer has to respond. And because of that, there is a delay in the decision-making. An officer has to perceive that, first of all, has to download a response mentally and then physically move. So the reaction time is a pure mental process, but movement time, for instance, is the time from the beginning to the end of the movement, raising a pistol up, for instance. So we put those all together and we come up with response time. And a subject doesn't have any type of response time. They're just acting. But an officer has to make a decision based on their perceptions. And there's going to be a delay there. If you have a prime decision maker, in other words, the officer is attentive and well-trained, et cetera, for anywhere from a half a second to 0.8 of a second at a time. Depending on the complexity of the move, depending on the officer's lack of attention, that can be up over 2 seconds, depending on the circumstances.
What human factors, if any, could have been at play here on August 24th, 2023?
Oh, variety of different things. Action response time, because Officer Grubb had to perceive the threat that Miss Young posed, download a mental response, and then fire the shot, as well as moving to try to evade being run over. The other part could be the mental aspects, things like attentional narrowing. When you're involved in something, I'm sure, to give you an analogy, you're driving in downtown Columbus and a car drives across in front of you and you slam on the brakes. You don't care about the pedestrian over here or anything going on. You're focused on not colliding with the car or something like that. So it's called perceptual narrowing, or tunnel vision is a common name for it. That our brain still perceives this stuff, we just don't find it, and we need to attend to it. So we focus in. We could get auditory exclusion or occlusion, which is tunnel hearing. I've been involved in shootings, for instance, in which, even though gunfire is really loud, it didn't sound that loud at the moment because you're so focused in. The body prepares for conflict by secreting powerful hormones, which develop this thing called the sympathetic nervous system reaction, or you, ladies and gentlemen of the jury, probably know as fight or flight. And that happens, heart rate increases, blood flow changes, all these things. As tension goes up, you have a SNS experience. So that could be part of it. There's a variety of different things, lighting, distance, timing, all those things.
What about policies? Did you review any policies here
Yes.
in this case?
Yes, the Blendon Township policy and procedure on use of force.
Does a violation of policy, hypothetically speaking, if we had a violation of policy, does that make a use of force unreasonable?
Not in terms of the law, because policy does not bind like law. Policy from an agency is a guideline. If an officer violates policy, it could be everything on, one time I parked in the wrong spot and I got 4 hours from internal discipline. That was violation of a policy. Violations of policy can include or end up with discipline up to and including termination. So yes, policy, an officer could even eventually be fired depending on the severity of the violation. But it's not a violation of law. We have court precedent, Smith versus Freeland in Ohio, or in this district, which says that it doesn't matter whether the officer can be disciplined by the local police force. It matters whether they violated the Constitution.
Now, did you find if there were any violations of policies here with respect to Connor Grubb and his use of force on August 24th, 2023?
No, not that I found.
Did you review a report by a man by the name of Seth Stoughton?
Yes, I did.
And what's your opinion regarding his report?
Professor Stoughton, I was struck by the fact that he cites himself 15 times in his report, and cites Graham v. Connor and Tennessee v. Garner, the legal standards, maybe a couple times or up to 7 times. But he cites his previous writings and his book 15 times. And that is not generally accepted police practices or standards in the state of Ohio.
Have you read his book, Evaluating Police Uses of Force?
I have, yes.
Is anything in here, in this book, Evaluating Police Uses of Force, in the OPATA curriculum?
No, I've never seen any citation or reference in the curriculum to Professor Stoughton's book.
What about generally accepted police practices? Are these generally accepted police practices anything in this book?
It could be. For instance, he does refer to Graham v. Connor and Tennessee versus Garner. However, Professor Stoughton refers to those as what he calls the constitutional floor. In other words, he believes and writes in his book and in other papers that he cites in his opinion that agencies can exceed the constitutional level, and they can in policy. Agencies can require the policy be more strict than the law. States can require that. For instance, Virginia, California, Washington State all have passed state laws that restrict officers' use of force more than the law allows. But in Ohio, you will not see Graham v. Connor, Tennessee versus Garner referred to as, in the curriculum for police officers, as the constitutional floor. That is the foundation for police use of force. And of course, we have State of Ohio v. White to help flesh that out.
You mentioned earlier another Supreme Court case, and I apologize because I forgot to write that one down, but you mentioned Scott versus Harris. What does Scott versus Harris tell us about generally accepted police practices?
Well, there's a lot in Scott v. Harris that applies in this case. For instance, it was a traffic case. Georgia police officer attempted to traffic stop a speeder, and the subject ran at high speed, and eventually the officer, because of the threat that the subject posed to pedestrians and other citizens, the officer made intentional contact of his vehicle with the subject vehicle, which caused the vehicle to crash. This was a case since Graham v. Connor and Tennessee versus Garner that applied, once again, the Fourth Amendment reasonableness test to that seizure, that intentional impact with the subject vehicle. But Justice Scalia wrote the opinion for the majority of the court, and he said we are loath or not willing to restrict officers or to lay down a rule where officers aren't allowed to attempt to stop somebody just because they engage in reckless driving, reckless speeding, or et cetera.
Now, in consideration of everything that you and I just discussed, Mr. Davis, for the last hour and 5 minutes, what's your opinion about whether Connor's use of force is reasonable to a degree of professional certainty?
I believe, based on my review of the materials, including digital video evidence, Officer Grubb's report, Sergeant Monahan's report, physical evidence, et cetera, that the use of deadly force was, though tragic, was within the law and within Blendon Township policy and within generally accepted police standards and practices in Ohio.
May I have a moment, Your Honor?
May.
Thank you, Mr. Davis. I have no further questions for you right now. I'm sure Mr. Brandt will have some questions for you, though.
Ladies and gentlemen, we're going to take our mid-morning break. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you. 15 minutes.
All rise.
Everyone can have a seat. Mr. Brad, I anticipated you taking more than a minute for cross-examination. Ready? Back on the record, 24 CR 4561, State of Ohio versus Connor Grubb. Do we need to put anything on the record prior to bringing in the jury? All right, let's go get the jury.
All rise.
Seat. Mr. Davis, you're still under oath.
Thank you, Your Honor.
Any cross-examination?
Thank you. Good morning, Mr. Davis.
Good morning.
I want to start off, if we may, I guess where the defense started off, and that's talking a little bit about your background and qualifications.
Okay.
We heard quite a bit about your law enforcement experience and training. But I want to ask you, sir, during your years with either, as I understand it, City of Akron or the Summit County Sheriff's Office, did you have any specialized training in the field of accident or crash reconstruction?
Other than basic academy and whatever in-service training, other than that, no advanced training.
Are you familiar with the organization known as ACTAR? And that's obviously an abbreviation, but the Accreditation Commission for the Traffic Accident Reconstruction.
I am not, no.
Safe to assume then you're not ACTAR accredited.
I am not, no.
Can you share with us, do you have, outside of your training in law enforcement, a degree in the area of biomechanics?
I do not, no.
Do you have a degree in the area of human performance?
I do not, no.
I take it you're not an attorney.
I am not, no.
And sometimes people go to law school and they choose not to be an attorney, sometimes for good reason.
Sometimes.
You didn't go to law school.
I did not, no.
Fair enough. You were also asked about your fees, sir, and I want to ask you a little bit about that. You mentioned that you were retained by defense counsel in this case. Is that right?
I have been, yes.
And you have a retainer fee of, I believe it was $3,500.
That is correct. With an oral opinion, if offered of another 500, that would be 4,000 if an oral opinion is given.
Now, do you charge an hourly rate on top of that?
I do, yes.
And how much is your hourly rate?
That is $300 per hour.
And how many hours, sir, do you think you've worked on this particular case?
Up until this morning, yesterday and this morning in prep, probably 35 hours.
Do you have an additional fee, sir, as it relates to in-court testimony?
Yes,
And what is that?
$2,500.
And do you also get reimbursed for travel expenses, hotel, meals, things of that nature?
Let's hope.
I want to talk a little bit, Mr. Davis, about your opinions, excuse me, regarding the Graham factors, and at least start off talking about one of the Graham factors, and that was severity of the crime. Do you remember talking about that, ladies and gentlemen?
I do, yes.
And was your opinion, I believe, that Ms. Young in this particular case had committed a couple of felonies?
At the time of the seizure, at the time of the use of force, yes.
One of those which you opined that she created or that she committed was the offense of felonious assault. Is that correct?
That is correct.
And you would agree with me, here in Ohio, there are essentially two ways to commit felonious assault. Is that correct?
Yes.
One way, and I guess I'll call it the first way, to commit felonious assault is to knowingly cause serious physical harm to another individual.
That's correct.
And in that particular crime, serious physical harm actually must be caused. Is that right?
As part of the definition, that's along with the part two that you're talking about, but yes, actually physically causing serious bodily harm, yes.
Well, that's an element of the offense. Would you agree?
Yes, along with the other section, correct.
And I'm only talking about this single section, just so there's no confusion.
Correct.
Felonious assault, serious physical harm to knowingly cause serious physical harm to another person.
Correct.
And in that crime, serious physical harm is a required element. In other words, it has to be proven or there is no felonious assault under that section.
No, that's not true. It's cause or attempt to cause.
I'm not talking about the second section, sir. We'll get to that in a moment.
That's in the same definition.
It's not. Would you disagree with me if I told you it was not?
I could read from my report.
And one moment, Your Honor.
You may.
Yeah, I have the Alamo. I'm referring to page 13 of your report, sir, just so we're on the same page here. See that?
Yes, two sections, correct.
And I'm looking at the bottom of page 13 where it says Ohio Revised Code, section 2903.11, felonious assault. And there are two sections or two ways to commit the crime of felonious assault. Is that right?
As I agreed to, yes.
Number one, under A1, is no person shall knowingly do either of the following. First, you can commit felonious assault by causing serious physical harm to another or another's unborn.
That's part of the definition, correct?
Well, that's the only definition to A1, correct?
But A2 is attempt to cause physical harm,
That's a separate crime.
but a crime of felonious assault.
Okay, well, I want to talk about A1.
Oh,
Let's not get confusing, okay? We're going to talk about A1 and then we'll talk about A2,
okay.
okay? A1, the crime of felonious assault, cause serious physical harm to another person. Causing serious physical harm is an essential element of that crime, is it not?
Of A1, yes.
And without actual serious physical harm being caused, there is no violation of A1. Would you agree with that?
No, not of A1, correct.
And you would agree in this particular case that the defendant, Officer Grubb, did not suffer serious physical harm, correct?
That is correct.
So we don't have any violation of A1. Would you be in agreement with that?
That is correct.
Now let's talk about A2. Felonious assault under A2 talks about causing or attempting to cause physical harm to another by means of a deadly weapon. Do you agree with that?
That's correct.
And under this particular section, or this method of committing felonious assault, the person would have to knowingly attempt to cause physical harm by means of a deadly weapon. Would you agree with that?
Yes.
I want to, if we can, may we move to the computer? It's going to be State's Exhibit 3. It's the defendant's body-worn camera, a portion thereof. You've reviewed the body-worn camera in this case, have you not?
I have, yes.
In fact, you used it as the basis of your opinions, at least part of the basis.
Part of the basis, yes.
I want to show you a clip of Officer Grubb's body-worn camera. We can play that.
Then get out. No, then get out.
Get out of the fucking car.
Get out of the car.
Get out of the fucking car.
You would agree with me, Mr. Davis. Actually, let's go back, and I want to look at that, and let me ask you to pay close attention to Miss Young and the positioning of her hands, okay, within the vehicle.
Then get out. No, then get out.
Get out of the fucking car.
Get out of the car.
Get out of the fucking car.
You would agree with me, Mr. Davis, would you not, that before the vehicle ever makes contact with the defendant, the body-worn camera clearly shows Miss Young physically turning her steering wheel to the right?
That's correct, as I testified to earlier, yes.
In fact, before Officer Grubb's weapon even comes into view, we can see her turning with her hands the steering wheel all the way to the right.
I don't know if it was all the way to the right, but to the right, yes.
I want to talk about aggravated robbery as well, because you mentioned that as a potential felony that I guess Miss Young was committing, in your opinion. Is that right?
That is correct.
And with it, as it relates to aggravated robbery requires that someone in attempting, committing the theft offense, or fleeing immediately thereafter inflicts or attempts to inflict serious physical harm on another. Would you agree with that?
That is correct.
So if we break this down, I think you would agree, based on your prior answers, that the actual infliction of serious physical harm did not occur in this case.
That is correct.
So we're left with the attempt, correct?
That is correct.
The attempt to inflict serious physical harm on another, in this case the defendant, would have to be shown. Is that right?
Yes.
And it would have to be proven that Ms. Young specifically attempted to inflict serious physical harm on the defendant, Officer Grubb.
By way of her actions, yes.
And you've already agreed that before her car even starts moving, she's turning that steering wheel all the way to the right.
No, I didn't say all the way to the right. I said turn to the right. I don't know to what extent.
Okay. Well, we do know, because we saw the video. It's not just a minor turn, is it?
Well, I don't know how much the wheel turns. I didn't operate the vehicle. I can't testify that it was all the way to the right.
Can you testify that it was hand over hand turning of the steering wheel?
It was certainly turning to the right, correct?
And not only do we see the steering wheel turning, we see the torque of the wheels go to the right in some of even the still images that you shared with us. Is that right?
Yes, the wheels are turned to the right, correct?
I want to talk to you about page 15 of your report, Mr. Davis, and that is a table regarding law enforcement officers being feloniously killed. Okay.
Yes, correct, correct.
Now, we've heard a lot of talk during the course of the trial about what the number one cause of death of police officers here in the United States is. So I want to ask you a little bit about your chart. You talked a little bit about it on direct. First, can you tell us, where is this chart derived from?
This comes from the Federal Bureau of Investigation, something called LEOCA, Law Enforcement Officers Killed and Assaulted Study. It's a study that's done every year by the FBI and published.
Can we have the computer, please? Thank you. talks about a time frame. It says law enforcement officers feloniously killed, type of weapon, 2014 to 2023. Do you see that?
I do, yes.
That's a 10-year time frame.
Yes.
And then underneath that, it talks about types of weapons, number of victim officers. On the line where we see number of victim officers, we see a total of 549 officers. Is that right?
That's correct, for the 10-year total.
For the 10-year total?
Correct.
That breaks it down by year thereafter.
Correct.
And I'm going to be looking at just the total column
Okay,
right now for my questions, just so you're aware, okay?
all right.
So 549, I'm assuming that relates to the total number of police officers feloniously killed in that 10-year period.
That is correct, yes.
Now, underneath that, we see total firearms. Is that right?
That is correct, yes.
And the number 480.
Yes,
So that 480 is the total number out of that 549 of officers that were unfortunately killed by firearm.
yes, that is the leading cause of death of officers.
And then we can see underneath total firearms, it breaks it down what I'll call individually, for lack of a better way to explain it, as handgun, rifle, shotgun, etc.
Correct.
And we even have some numbers there toward the bottom under total firearms of types of firearms, not, I guess the type of firearm wasn't reported, whether it was a shotgun versus a handgun, rifle, that type of thing.
Correct,
And that number is 87 for the record.
yes.
I want to go down a little further, and we can see where it says vehicle. Total officers killed by vehicle is 47, is that right?
In that 10-year period, that is correct.
Now, you would agree 47 is less than 480. I don't mean to sound facetious, but
Under the circumstances, one is too many, I think you'll agree, but yes.
absolutely. In fact, 480, the number of times an officer has been killed by a firearm is over 10 times the number of times an officer was killed by a vehicle during this 10-year period. Would you agree with that?
That is correct.
So if witnesses throughout the course of this trial were told that the leading cause of death of officers here in the United States was a motor vehicle, that would not be true, would it?
No, primarily during the 10 years and past years, it's firearms, but primarily handguns, as we can see, are the biggest thing, biggest firearm used against law enforcement officers.
Now, you've testified in other states, is that right?
I have, yes.
You told the ladies and gentlemen that you now make your living, that you're retired as an expert witness consultant, that type of thing.
I wouldn't say I make my living, but I run a business where I consult and offer testimony, yes.
But you're paid for it.
I am. I don't know whether I make a living out of it, but I am paid, yes.
$300 an hour is not bad. Would you agree with that?
It's not like an attorney where you have constant clients, counselor.
You've never worked as a police officer in any state other than Ohio. Is that fair to say?
No, just in Ohio.
Albeit you've not worked outside of Ohio as a law enforcement officer, you've gone to other states other than Ohio to testify as a use of force expert.
Testify and to train officers, yes.
You've testified in a number of police officer shooting cases. I think you've told us that on your direct testimony. Is that right?
I have, yes.
And you've written probably even more reports on cases than you've testified.
Yes.
And in those reports, you state your opinions and the reasoning behind those opinions.
Yes.
Every case is different. Would you agree with that?
Every case is different, yes.
Each case involves different facts, different circumstances.
That's correct. Same legal standards, but yes.
You issued, I believe, 3 reports in this case. Does that sound right? You have an original report dated July 30th of this year, 2025, which the state received the following day on August 1st. And then there were some, I guess, corrections made to a report,
Typos, yes.
and that was issued sometime around November 11th. Is that fair?
Yes, I believe that's the correct date.
And then there was a third report, what I'll call a third report, with some additional, I guess, corrections made that was issued just over this past weekend.
That's correct, typos. Mhm.
And I want to understand, and do we have a slide? Can we get the computer? As it relates to, and I want to talk about page 66 of your report, if you have it in front of you. If not, I have it up here on the screen.
Okay,
On the left is the November report, the July report, and the November 11th, and the November, those two first reports. But I just want to make sure that we're talking about the same typos. On the right-hand side is the one that you just issued this weekend. Would you agree with that?
correct. That was a correction to typos in the report on the left.
In the names?
Correct.
Okay. So for instance, and I've highlighted these just for the record, for instance, on the left in that paragraph, we have the wrong officer's name, albeit Officer Anderson, and the wrong, I guess, victim or individual that maybe was shot, Lewis,
That's correct.
and then Officer Anderson's name again, and now you've corrected that to be Officer Grubb, and Young, referring to Miss Young, and then Officer Grubb again, is that right?
Yes.
The rest of that wording in that paragraph essentially looks to be exactly the same. Would you agree with that?
Well, it's written for Officer Grubb's case. I can't recall, what, proof positive that AI didn't write my reports, that there is human error and typos, et cetera. So I can't recall what that was about, but I did catch it prior to trial.
Essentially cut and paste error.
No, I don't believe that's accurate. The one on the left is for this case. It was just the wrong names were included.
Well, the one on the left talks about Officer Anderson, but you're saying that was for this case, you just typed in the wrong name?
I can't recall, Counselor.
Are there portions of your report that contain the same language that you've used in other reports?
Primarily, it's citations to the legal standards, but I think that is pretty much industry standard with all experts, yes.
You can take that down. As part of your analysis in this case, Mr. Davis, you indicated that you looked at the Blendon Township police policies. Is that correct?
I did, yes.
You have the Elma. I'm going to look at, for the record, page 72 of your report, sir. Referring you specifically to the section that talks about 300.4.1 entitled moving vehicles. Do you see that section?
I do, yes.
And that's part of Blendon Township's written policies, is it not?
Yes, they're guidelines for their officers, correct.
Where it says, shots fired at or from a moving vehicle involve additional considerations and risks and are rarely effective. Would you agree with that?
Correct.
And this policy specifically tells an officer that they should take reasonable steps to move out of the path of an approaching vehicle instead of discharging their firearm. Would you agree with that?
When feasible, yes,
When feasible.
correct.
And it additionally states the officer should only discharge their firearm at a moving vehicle when the officer reasonably believes there are no other reasonable means available to avert the imminent threat of the vehicle.
That's correct.
Now, police policies are not case law, correct?
They're not legal standards, correct?
But they are put into place for a purpose.
There are guidelines to inform and guide officers on the street, yes.
They're put in place to protect the officer. Would you agree with that?
Both the officer and the public, yes.
And officers are expected to follow the department's guidelines, are they not?
There's a ton of different guidelines and policies for most agencies, and they usually rank them. Use of force would be at the top in terms of criticality, but other things like where you're supposed to park are not so critical. So there's a ton of different guidelines and policies.
Where you're supposed to park your vehicle is not critical, but when you shoot at someone is pretty critical. Would you agree with
That is correct.
I want to move on to your report, and I think it's somewhere around page 20 of your report, just for your reference. And beginning on page 20 of your report, you make a point of quoting the defendant's written statement that was provided to investigators in this case. And then I believe you go through various video segments or screenshots from videos and attempt, according to what you state in your report, you attempt to quote unquote confirm essentially the words that were used in the defendant's written statement, or did it happen how he said it happened?
To develop totality of the circumstances to make a determination on whether I believe that the use of force was reasonable or not, yes.
And on page 20 to 21 of your report, you actually quote a portion of the defendant's written statement. Would you agree with that?
That is correct.
And you're quoting on those pages of your report a section of the defendant's statement from page 3 of his written statement. Would you agree with that? And I can give you a copy of that if it would help you.
It would help, thank you.
May I approach, Judge?
Ready?
I'm going to show you, Mr. Davis would have been marked previously as State's Exhibit 66.
Okay.
Copy of the defendant's written statement, or typewritten statement, I should say.
Yes.
And I was asking you about the portion that you quoted on page 20 and 21. And I believe that comes from excerpts from page 3 of his statement.
Starting on page 2.
And your quote ends with wording from, what would you say, page 4?
Yes, page 4, correct.
And you took those words, albeit from page 2 to 4, that the defendant put in his statement, and you reviewed the video, correct?
I reviewed the entirety of his statement as well as reviewing the video, yes.
Well, there were portions of his statement that you didn't put in your pages 20 to 21 or 20.
Well, I'm sure there is, it's a 6-page total statement. I didn't include all of that.
Well, I want to talk about a portion that you didn't provide, okay?
Okay.
At least that you didn't put in your report, all right? And that's going to be a section from page 5.
Go ahead, sir.
Would you agree with me, from what you've looked at, you didn't put any portion quoted in your report from page 5 of the statement?
Not in this section that I can see, no.
I want to retrieve that from you. We have the Elmo, please. And the section I'm referring to, Mr. Davis, is the sentence starting, "At the time I fired my weapon, At the time I fired my weapon, I was in fear for my life.
I'm sorry, let me try to find that. Okay, at the beginning, at the top of the page. Go ahead, sir.
At the time I fired my weapon, I was in fear for my life as the suspect had just struck me, with her vehicle. My feet were no longer on the ground and the top half of my body was on the hood of her car. You see that?
I do, yes.
Now would that be an important statement for you?
Yeah, it coincides with the body-worn camera videos, yes.
With his top half of his body being on the hood of her car?
His feet off the pavement and his torso over the vehicle, yes.
His top half of his body on the hood of her car. Did you see that in your video analysis?
I don't know that I saw that specific thing. I took that to mean that over the vehicle, or over the hood of the vehicle, yes.
You were interpreting the defendant's words for him?
No, that's what I took that to mean. I can only interpret based on my opinion, yes.
Well, why didn't you interpret it to mean exactly what it says, that his top half of his body was on the hood of the car?
It doesn't say lying on top of the hood of the car.
Oh, okay. Now, you reviewed a number of items of discovery regarding this case, is that right?
I did, yes.
And obviously, the video was an important part.
Video is plural, yes.
And the defendant's written statement was an important part.
That's correct, yes.
Anytime a defendant, officer in this type of case, gives a description as to what he alleges happened to cause him to discharge his weapon, that's an important statement.
Yes, that's correct.
And it was your intention to compare what he said in his statements to what you saw in the videos.
Yes, to develop totality of the circumstances at the moment that he used force, yes.
Now, I never saw in your report, and your report is 70 plus pages, is that right?
I think it's actually 89 pages. Oh, I'm sorry, more than that, 91.
In those 91 pages, I did not see any reference to a statement that the defendant made to Westerville Fire Department medics. Did you include that in your report?
No,
A statement, just so I'm clear, a statement that the defendant made to Westerville medics, telling the medics what had happened as the car allegedly hit him and caused him to discharge his weapon. You did not put that in your report.
I did not know.
Any particular reason?
Based on his statement and the body-worn cameras, my focus was on the use of force, not articulation afterwards in terms of third parties or what have you.
I don't know what that means. Help me understand what you just said. I thought you were telling us earlier that it would be very important for you to know what statements the defendant made to someone describing the events that caused him to discharge his weapon.
Well, certainly his statement is his version of events that justify his use of force, or as he is attempting to articulate his use of force. That is looked at versus statements to third parties. There was no focus on that in my investigation. I focused on the moment that force was used.
You're aware that the defendant was taken away from the Kroger scene in a sheriff's cruiser, are you not? Seen at Kroger, I should say.
Taken away
After
from
the
the scene,
shooting.
yes, officers usually transported away from the scene, correct?
He was driven back to the Blendon Township Police Department.
Yes,
And once he was back at the police department, there were some Westerville medics that were asked to essentially evaluate him for any potential injuries. You're aware of that?
yes, I'm aware of that.
And you're aware in the course of his contact with those medics that he did make a statement telling them what had occurred.
I remember seeing that in Discovery, but it was not the focus of my investigation.
Well, let me ask you, are you aware that he told medic Nick Adkins that when the vehicle struck him, he was thrown off of the hood and onto the ground?
I don't know that that is not in keeping. He was certainly propelled off the vehicle, so I don't know the specifics. I would let his statement stand for itself in terms of what he felt at the moment that force was used.
Okay, well, let's break it down because that wasn't exactly my question. My question was, were you aware that the defendant made the statement to Medic Atkins that he was thrown off of the hood of Miss Young's car and onto the ground? Were you aware that he made that statement?
As part of discovery, I was afforded that statement, yes.
And you chose not to put that in your report?
That's correct.
We just got done talking a little bit earlier about, on page 20 of your report, when you were taking excerpts from the defendant's written statement and quoting them in your report. You remember that?
Yes, his official written statement of what he stated transpired, yes.
And you were comparing what he stated transpired with what you saw actually happen on the video, correct?
That's correct.
That's part of your analysis.
That is correct.
What you're getting paid to do.
That is correct.
You're not telling the ladies and gentlemen that Nick Atkins was lying, are you?
I don't know what, if or what Mr. What's his name?
Medic.
The medic, what the medic testified to. I'm not aware of that.
Well, he testified to the statement. You're not saying that that's untrue, that the defendant made that statement to him, are you?
Once again, I'm not aware as to what he testified to.
Nowhere in the video analysis that you performed in this case, Mr. Davis, did you ever see the defendant be thrown off of the hood of the car onto the ground? Would you agree with that?
It depends on what throw means, counselor. Thrown to the ground, that his torso hit the pavement, that didn't happen. But was he propelled off the front of the vehicle and recovered at the side of the vehicle? Yes, that happened.
Well, we're playing some word games here, I feel like. I'm just gonna go from what he said, that he was thrown off of the hood onto the ground. Did you ever see that happen?
Yes, he landed on the ground, counselor.
You did.
He landed on the ground, yes.
You're telling the ladies and gentlemen that this defendant was thrown off of the hood and landed on the ground.
Yeah, his feet, it's in the video.
His feet.
Well, I'm sorry, that's landed on the ground. He didn't land on something else. He landed on the asphalt of the parking lot, counselor.
So you, again, are interpreting the words thrown off of the hood and onto the ground to mean that I landed on my feet.
I don't think it was that motion, counselor, but we can watch the video and see Officer Grubb propelled off the front of the vehicle and recover his footing on the side of the vehicle.
You would agree with me, Mr. Davis, would you not, that if the information the defendant gives as to the events that led him to fire his weapon is determined not to be true, that that could affect the reasonableness of any perceived threat?
I don't see any, he landed on the ground, that's all I can say.
That's not my question. My question to you is if the information that this defendant gives as to the facts that led him, the events that transpired that led him to fire his weapon are not true, that could affect the reasonableness of a perceived threat.
If that's found in the case, yes.
Now, you mentioned a little bit, you talked a little bit about positioning, cover, contact and cover. Remember that?
Yes.
And you talked about the position that the defendant took at the front of the vehicle, correct?
Correct.
And you talked about other areas where he maybe could have stood, but I guess in your opinion wasn't a tactical sound idea.
Well, they're subjective. So he could have stood in other areas, but the question was, when he stood in front of the vehicle, was that tactically sound? And based on the circumstances, yes.
And you mentioned specifically that he could have stood in the back of the vehicle. You remember saying that?
No, I said that, the problem with that is limited visibility in terms of seeing the occupants. Obviously, you're behind the seats, you're behind the driver.
And you talked about the reason he may not be able to see is because of the window tint, remember?
That's a possibility.
Now, you didn't measure the window tint of this Lexus, did you?
No, I did not.
Have you ever even physically seen the Lexus in person?
No, I have not.
You don't know what, if any, tint may even be present on that back window. Is that fair to say?
No, other than watching the video.
You also said that he could have stood next to Sergeant Moynihan.
I believe the question was that a possibility? And the answer is yes, he could have stood in a variety of different positions around the vehicle.
One of the factors an officer should consider in terms of where they're going to stand is whether they're going to be in crossfire. You mentioned that.
That is correct.
And that not only includes crossfire with another police officer, but that would include crossfire with innocent civilians, would it not?
It's a tough situation in a parking lot or in the totality of the circumstances as in Kroger because of you had people pretty much 360 degrees around the vehicle.
Well, you watched the video, am I right?
I did, yes.
And you're aware there were people not on the outskirts of the parking lot, but right next to the vehicle, citizens. Did you see them?
On the passenger side, there was a citizen, and to the rear of the vehicle, we know there were citizens, but they were involved with a lockout. There were also, I believe, other persons to the south or to the front of the vehicle in the parking area.
Now you say, but they were involved in a lockout. They still are subject to being shot, potentially, are they not?
Oh, yes.
You mentioned, Mr. Davis, about body-worn cameras and talking about them not being, I wrote down the quote, they're not real life. Do you remember that?
It's not the real event. It's a two-dimensional image of what the camera captures, correct?
But you used the body-worn cameras in forming your opinions, did you not?
I use all the digital video evidence,
Kroger included.
the surveillance cameras, correct?
May I have a moment, Judge? That's all I have right now. Sir, thank you.
Thank you.
Any redirect?
May I inquire? Thank you. Mr. Davis, I want to start where Mr. Brandt kind of left off. Did you hear him make a comment about wordplay?
Yeah, well, I'll extrapolate, Counselor, ask it about a
Do you
different
remember
question.
when he asked you why you included Connor's statement of being thrown off the hood of the car, or his partial body on the hood of the car, those and how they intermix?
Yes,
Does Connor's words of either being thrown off the car or having his partial body off the car change the fact that he was hit by that car?
no,
Does that change whether or not being hit by a car is an imminent threat?
no,
Was the car an imminent threat on August 24th, 2023?
yes.
Why is that, sir?
Because of the vehicle had, Ms. Young had accelerated the vehicle into the officer as he was in the front of the vehicle.
Do you remember the questions Mr. Brandt asked you about what it was that Connor told the medic?
I do, yes.
If I told you he told every one of the medics that he got struck by the car, is that consistent with perceiving an imminent threat?
Yes,
When medics ask a person questions, they're asking for treatment purposes. You would agree with that, right?
in my experience, yes.
Your purpose isn't to treat Connor, is it?
No,
Your purpose is to analyze whether or not the use of force was in fact reasonable. Is that correct?
That is correct.
The reason why you included his statement is because you prefer his words over a medic's words, right?
They're a direct version of his events as recorded to investigators, yes.
You would agree with me that the report you reviewed by the medic was written by the medic, right?
Yes.
So anything in that statement is coming from a third party. Would you agree with that?
Filtered through a third party, yes.
I want to talk to you about the policies that Mr. Brandt talked to you on direct examination. Do you remember the policy? I think it's on page 72 of your report, 300.41.
Okay,
You're at that policy?
I am, yes.
And it says the keywords there are when feasible. Would you agree with that?
Yes, the counselor didn't include that in his question, but when feasible, yes.
And what does it say for the ladies and gentlemen of the jury?
When feasible, officers should take reasonable steps to move out of the path of an approaching vehicle instead of discharging their firearm at the vehicle or any of its occupants.
Was it feasible here?
No, because of the circumstances, no.
The circumstances of the 1.665 seconds?
The circumstances that Ms. Young, created by accelerating her vehicle into the officer, yes.
When you accelerate a vehicle into an officer, is that an imminent threat?
It can be, yes.
Should Connor have just let her run him over?
No, he has he has a responsibility to protect his own life.
Thank you, Mr. Davis.
Mr. Brand, any questions as a result of those?
Based on your review of the discovery, Mr. Davis, you're aware that medic Nick Adkins was not at Kroger when this shooting incident occurred, correct?
That is correct.
So any information he documented in his report in terms of statements would have come directly from the defendant, is that right?
If it's an accurate report, yes.
You were asked questions, can I have the Elmo, please? Thank you. You were asked questions about the Blendon Township policy, and the officer should make every effort to move out of the way when feasible.
I think it's the opposite. When feasible, the officer should make every time.
I want to show you one of your still photos here. This is a still photo from your presentation earlier this morning. Would you agree with that?
That was one of the, yes.
There's nothing behind the defendant to preclude him from taking steps backwards. Would you agree with that?
Nothing behind him?
Yes.
No, nothing behind him.
There's nothing precluding him from taking steps to the right. Would you agree with that?
Well, it's very tough to move laterally when force is applied to you, into you. That makes sense. And the vehicle is moving into him. And at that time, it's very hard to move under those circumstances.
One of the things you talked about is the video doesn't show us the perception of what the officer is feeling.
Objection, Your Honor. I didn't ask any questions about that perception of the officer on cross-examination on the body-worn camera.
Counsel, one approach?
Yes, Your Honor.
May I inquire, Your Honor?
You may.
Mr. Davis, you can't personally tell us what sensation Officer Grubb may have been feeling at that moment. Would you agree with that?
No, I cannot. I can only go from his statements.
That's all I have, Judge. Thank you.
All right. Ladies, counsel, one approach?